I hope you enjoy my stories. Instead of just clicking thumbs down, please comment and share how we can do better. If you do like our video, then please like and subscribe.
HOA wants me to get rid of my car in a parking spot I specifically own. My parents were the proud owners of 2 cars.
However, tragedy struck 2 years ago when my father passed away, leaving his car sitting idle in our designated parking spot. In the time since, we've occasionally faced issues raised by the president of the association, prompting us to move the car upon request. Despite our compliance, the matter of my father's car is now on the agenda for the upcoming board meeting.
The president claims it's illegal to leave a car unmoved for more than 10 days in the state of California. This assertion has left me puzzled and worried. Our parking situation is tight. We own the unit, but have only 2 designated parking spots.
The presence of my father's car has occasionally caused inconvenience, but we've always addressed any concerns promptly. Now it seems the issue is escalating. I wonder about the legality of the situation and whether there's anything we can do to resolve it.
The parking spots are designated to specific units, meaning no one else can park in them anyway. My father's car being there doesn't inconvenience anyone. It's not blocking access or causing any safety hazards.
However, I can't help but suspect that the president's focus on my mother and her late husband's car is personal.
There are other more pressing parking issues within the community that seem to go unaddressed. For instance, one resident consistently parks diagonally, taking up 2 spots that he owns.
Another family habitually parks in the disabled spot and the walkway, despite there being an actual disabled person who could use that space. It's frustrating to see these issues ignored while my family is being singled out.
I live in California and am aware of the 72-hour parking law, but I'm not sure about the 10-day rule the president mentioned. Any advice or specific laws related to this situation would be greatly appreciated. My father's car does have its issues, notably with its tires, which are in poor condition.
Despite this, the car is still operational.
I've kept it because it holds sentimental value for me. It's a keepsake of my father's memory, and I've wanted it since I was 7 years old.
The car carries memories of family road trips, outings, and the countless moments shared with my father.
It's more than just a vehicle. It's a symbol of our bond and shared experiences.
So even though it may not be in perfect shape, its value to me goes far beyond its practical use. The Homeowners Association is pressuring me to move my father's car, which occupies a spot designated to my specific unit. According to them, it's against California law to store a car in the same spot for more than 10 days.
This demand has put me in a difficult situation.
Firstly, my father's car isn't simply stored. It's a sentimental keepsake with its own significance. Additionally, the spot it occupies is rightfully mine as part of my unit, and it's not impeding anyone else's use of the parking area. As for my options, I could start by clarifying the specific law the HOA is referring to. While I'm familiar with the 72-hour parking law, I'm unsure about the 10-day rule they've mentioned. Researching the state's vehicle code or consulting with a legal expert might provide clarity on this matter. I could also bring up the inconsistency in the HOA's enforcement.
There are other parking issues within the community, such as residents using multiple spots or parking in designated disabled spaces illegally. Highlighting these issues may help demonstrate that my situation isn't unique, and that the HOA should prioritize addressing more pressing concerns.
Furthermore, I could appeal to the HOA's sense of fairness and understanding. Explaining the sentimental value of the car to me, and the fact that it's not causing any harm or inconvenience to others, might encourage them to reconsider their stance.
If discussions with the HOA don't yield a satisfactory resolution, I may need to seek mediation or legal advice to protect my right to keep the car in its current spot. Ultimately, I hope to find a solution that respects both the HOA's regulations and my personal attachment to the car. The car is insured and was fully registered for the past 2 years.
However, recently we adjusted its registration status to reflect that it's legal and registered, but not for public road use.
Despite this change, the car remains fully covered by insurance. Considering the pressure from the HOA, One option could be to frequently move the car between my designated parking spots. It's not an ideal solution, but it might alleviate some of the HOA's concerns while allowing me to retain possession of the car.
It would require some juggling, but it might be a manageable compromise. I'll either swap parking spaces from time to time or implement one of my favorite suggestions I read here, simply turning the car around.
This way, it technically appears to be in a different position, but it remains in the same spot. ROM. A cluttered front porch to a jeopardized home. The continuing saga of an elderly woman and her condo association.
Rosita Sipirox-Sarigar's Makakilo home may not always be in perfect order, she concedes. Yet the septuagenarian retiree never anticipated the severe measures her condo association would take due to what she considers minor infractions.
In a bewildering turn of events, her tidy issues escalated into a legal battle when her condo association decided to enlist the services of Honolulu lawyer Kapono Kiakona. The legal fees amassed quickly, ballooning to $3,300, all to collect a sum, just over $300, in alleged fines from Sipirox-Sarigar. As tensions mounted, matters took a dire turn in December when Sipirox-Sarigar received a notice from Kapono that her association was considering foreclosure on her property to recuperate past due payments.
This episode marks the latest in a series of disputes between condo owners and associations across Hawaii, prompting calls for legislative action to protect homeowners like Sipirox-Sarigar.
Bills aimed at addressing such issues faced deadlock in the 2023 legislative session, but may find new life in 2024, offering hope for resolution to those caught in similar predicaments. Sipirox-Sarigar admits that occasionally her front stoop has been cluttered, and her shoe rack doesn't meet the association's specifications, a rule her next-door neighbor also disregards. However, she firmly believes that the Association of Apartment Owners of Westview at Makakilo Heights is being unjust in their attempts to force her to sell her home.
They're targeting an elderly single woman, she says. I'm a law-abiding citizen, yet I'm being cited for something as trivial as having shoes on my front porch.
While Sipirox-Sarigar plans to challenge the fines and charges against her through mediation, this legislative session presents an opportunity for lawmakers to examine the broader laws governing such disputes and condo associations in general.
Several bills carried over from the last legislative session aim to reform the way condo associations operate.
One proposal offers an alternative to mediation for individuals like Sipirox-Sarigar. The fate of such bills remains uncertain. Representative Luke Ebslin, chairman of the House Housing Committee, dedicated much of the summer to other housing issues. He intends to propose bills aimed at increasing housing density in urban-zoned areas to encourage home construction, while safeguarding agriculture and conservation land. However, Ebslin expressed concern over what he views as excessive power wielded by homeowner associations at the expense of residents during his tenure as a Kauai council member. He played a role in passing county legislation to curb these practices. While Ebslin hasn't ruled out holding hearings on bills addressing condo associations at the state level this session, he recognizes the complexity of the matter. Condominiums operate as private self-governing entities, governed by various bylaws and house rules. These documents serve as contracts between condo owners and associations enforced by elected boards. Typically, these boards hire management companies, lawyers, contractors, and consultants to manage operations, with all expenses borne by owners. Frequently, compared to private governments, these associations wield significant authority. They can generate funds through fees and assessments, impose fines on owners, and in certain instances, initiate foreclosure proceedings, compelling homeowners to sell their properties to settle debts with the association. Additionally, owners often bear the burden of covering the legal fees incurred by lawyers acting on behalf of the associations. Nevertheless, these associations operate within the parameters of state law, primarily governed by the Hawaii Condominium Statute. Oversight falls under the Department of Commerce and Consumer Affairs Real Estate Commission, consisting entirely of real estate brokers and lawyers.
Representative Luke Evslin, chairman of the House Housing Committee, indicated that he is open to considering any bills aimed at amending Hawaii's condominium law this session.
One proposed bill aims to reform condo elections to mirror those of public office elections more closely. Another seeks to establish an open records law for condo owners, granting them access to inspect and copy various documents that associations are required to maintain under condo law. A third bill proposes the establishment of a condo ombudsman to act as a resource for members of condominium associations.
This role includes ensuring associations comply with existing laws and governing documents, as well as assisting in dispute resolution without the need for legal representation. I wouldn't dismiss any of these bills, Evslin stated. However, I must admit that I'm not familiar with the specifics of many of them, so I can't comment too extensively.
Bills aimed at reforming Hawaii's condo law encounter obstacles.
It's tempting to dismiss them outright because they frequently fail to progress.
For instance, the open records and ombudsman bills were not granted hearings last session.
Even bills that do receive hearings often encounter opposition from condo lawyers, associations, lobbyists, and consultants who advocate for the current system.
The proposed bill aiming to change condo board elections encountered opposition from various groups. The Hawaii Council of Community Associations, a lobbying group, and the Hawaii State Association of Parliamentarians, whose members are often hired by associations to facilitate board meetings, were among the opponents. Additionally, Kapono Kiakona's law firm, Porter McGuire Kiakona, known for accumulating substantial bills on behalf of associations against owners, testified against the bill.
Furthermore, several current association board members submitted identical testimony opposing the bill.
One of the few voices in support was Lila Mower, president of Kokua Council, an advocacy organization that has been advocating for legal changes to benefit individual owners. In an interview, Mower highlighted that Siparak Sirigar's situation, where she faces an alleged $1,133 in unpaid maintenance fees, fines and late fees, along with $3,366 in legal fees, is not uncommon.
The situation where what she really owes is $1,000, but Kapono's fees are 3 times that. That's not unusual.
Sometimes it's more than 3 times, said Mower, who was appointed by House Speaker Scott Saiki to a legislative working group tasked with studying condo issues.
It's sadly not unusual.
Mower emphasized the importance of making it easier to vote out board directors who condone such behavior.
It's excruciatingly difficult to oust board members, she said. Homeowner acknowledges mistakes. Siparak Sarigar admits that she has occasionally left items such as a broom or mop on her front stoop, violating house rules.
Additionally, her shoe rack does not meet association specifications, which require a 2-tier white or off-white rack. However, on a recent morning, her rack was hidden from street view by a pillar, as were a vacuum cleaner and trash can she had placed near the front door. Siparak Sarigar also concedes that she hasn't opened many of the numerous letters she has received from Kiakona. The association's lawyer stated that he couldn't comment on the pending matter without written authorization from Siparak Sarigar, which she had not provided. However, among the letters from Kiakona that Siparak Sarigar did open, one sheds light on the association's demands and potential paths forward for her. Dated December 14, 2023, and titled Notice of Default and Intention to Foreclose. The letter indicates that Siparak Sarigar owes $4,499.88 in delinquent assessments, other charges and attorney's fees and costs unpaid to the association. Although the letter stipulates that Siparak Sarigar must pay $4,938 to bring her account current, she can remove the lien on her property and notice of intention to foreclose by paying $438.49. The letter also outlines Siparak Sarigar's rights, stating that she has the option to submit a payment plan and request mediation.
Additionally, it suggests that she consider hiring an attorney to better understand her potential legal rights and defenses. However, this would entail paying for the services of 2 lawyers, her own attorney and Kiakona, who represents the association.
Thus, while seeking legal counsel could provide valuable guidance, it also poses the challenge of additional expenses. Siparuk Sarigar finds herself in a state of confusion regarding the situation, grappling with the sobering reality that the association has the authorities on her property to collect payment under Hawaii's condo law. Despite this, she vehemently denies the assertion made in Kiakona's letter that she has fallen behind on paying maintenance fees.
For her, this discrepancy adds another layer of complexity to an already convoluted situation.
Nevertheless, Siparuk Sarigar remains optimistic about resolving the matter through mediation.
She sees it as an opportunity to clarify misunderstandings and reach a fair resolution.
Amidst the legal intricacies and mounting pressures, she holds on to the hope that mediation will provide a path towards resolving the dispute amicably and without further escalation. Whether a resolution is reached through mediation remains uncertain. Leila Mower has compiled reports published by the Real Estate Commission dating back to 1991, which suggest that mediation results in an agreement in less than one-third of cases, according to her findings.
This statistic underscores the challenges inherent in resolving disputes through mediation and highlights the complexity of the issues facing condo owners and associations alike.
Mower and other owner advocates are of the opinion that an ombudsman could be significantly more effective in resolving disputes between owners and associations. While the effectiveness of an ombudsman remains debatable, Mower argues that the current practice of associations resorting to legal action against owners at the owner's expense primarily benefits lawyers.
If the associations want to be good neighbors, there are plenty of alternatives, she pointed out.
Where's the reasonableness? Where's the rationality? Where's the humanity? Mower emphasizes the need for a more humane and reasonable approach to resolving conflicts within condo communities, one that prioritizes cooperation and understanding over legal battles.
I would like to thank you for watching the video to the end. To encourage us to make more videos, please like, subscribe, comment, as well as share. Check out this other video if you haven't already.